Hi guys, thanks for coming on Friday night instead of going out and, I don't know, getting drunk or something. Of course you can, if you drink later during the talk, I won't know and I won't mind. I suppose you want to know who that coffee is for. It's for me. If you guys fall asleep, it's okay, but if I fall asleep, it's a big problem. So, anyway. Seriously, this is a talk on intellectual property law. It is designed for non-lawyers. In fact, this is pretty much the same talk I give in my classes on law. I teach a class called Intellectual Property and Information Technology. And this is pretty much the same presentation. However, for the lawyers who are scared of technological things, I tell them that the class is not technical. And since you guys, I understand, all have some technical backgrounds, I just tell you this is not legal. So, okay? So, we will talk about intellectual property. I will call it IP. So when I talk about IP, I mean intellectual property, not Internet Protocol. Okay? And for those of you who also wonder, I actually do have an IT background. I used to work in IT, so I do know something about IT. I'm also a forensics examiner in digital forensics, so I do at least know how to get data off of a computer and then give it to somebody who knows what he's doing, or do it myself. This is going to be an overview. I am going to give a very idealized picture of intellectual property. There are many things that I will not be covering. There are many exceptions to what I talk about that I will not cover. There will be many controversial areas that I will not cover. Okay, this is just an overview, but I do tell you this is going to be a fairly intense subject, even as an overview. It is fairly complicated. A lot of lawyers find this complicated. So if you have any questions, just feel free to ask me even during the presentation, okay? So just keep it relaxed. Let me start by talking about what is the purpose of intellectual property and why it's relevant to people like you and most people. You guys are all, as I understand, involved in design or development work. So you guys create things. You're innovating things. And so the idea of intellectual property law is to protect people who create things, to protect their creations, to protect their inventions, their innovations, because these things benefit society. Copyright, for example, which we'll talk about a little bit later, protects creative works. And the advantage to society is that you get, great music, great books, great games, great software, etc. Patents, for example, are there to encourage innovation. And the idea of the benefit of innovation is, you've got cool things to play with, cool things to use, things that help you in your work, in your life. Now, a lot of countries are interested in IP law, and to them IP law is very important. If you look at the United States actually has a clause which says to promote the progress of science and the useful arts by securing for a limited time to authors and inventors the exclusive rights to their respective writings and discoveries. So this is a statement in the United States Constitution, the highest law in America, that it is important to protect intellectual property rights. And if you look at the numbers from 2009, according to the United States, their intellectual property was worth something like $5 trillion US. And to put that in perspective, that is actually a little bit more than the GDP of China in that year. So according to the United States, in 2009, the value of their IP economy was bigger than the value, the GDP of the world's second biggest, which is currently the second biggest economy in the world. And a lot of countries are very much into IP. They make a lot of money from it, and I mean net money, not they make money but then they lose it in some other areas. Countries like America, of course, Japan, England, France, and interestingly enough, Sweden. So let's talk about some other perspective of IP. And I want you to keep this in mind when I talk. And I'll slow down when I get to the legal stuff later. Intellectual property rights are really valuable, and they're really only valuable if you are willing to pay the price to get them. Now, some rights come automatically for free, like copyright, and others, like patents, can cost money. And if you look at the price of getting and maintaining the average European patent, you could buy one of these. And I point out that the biggest difference between the presentation that I give you guys and the one I give in my law class is this slide. In the law class, I use a BMW. This car has more software than a BMW one, so I figure you guys would probably appreciate that more. If nothing else, it was newer than the card used in my other picture. But even though intellectual property rights are maybe expensive to obtain, they can be really expensive to enforce. I mean, because if you look at the price of litigation, taking a patent infringer to court in America, patent cases cost something like 10 years ago, the average cost in the United States was $3 million US. So that's a lot of money. And look at it this way. If you spent $300,000, $400,000 to get a patent, and you didn't do anything with it, you didn't enforce it against somebody who was stealing your invention, then what was the point of spending all that money? So you have to think about intellectual property rights as something that you would be willing to obtain, maintain, and protect. And with that in mind, let's start. The intellectual property rights that you see listed here include pretty much all the IPRs that are available to people. And there is one more up here called, well, okay, my laser doesn't work, my pointer doesn't work, but unfair competition and passing off. And that actually is not an intellectual property right, it's actually legal. It's actually competition law, but we'll talk about this in intellectual property context. So let's start with the oldest of the IPRs, intellectual property rights, and those are patents. Now, there are actually several things that are called patents, and I just point this out because people get confused over this. The one thing that most people think about with a patent is the invention patent. It's the thing that lasts 20 years, and it's to protect. Oh, thank you. All right. Okay, invention patent. It lasts 20 years. Sometimes you hear people talk about design patents. It's actually, design patents are a design right. I will talk about these later. You may see something called a plant patent. It is in America, has plant patents, and these are designed to protect plants. Now, since you guys are in IT and games, and I don't think plants are really that important to you. And then some countries have something called a petty patent, a utility patent. Hong Kong has a short-term patent. These are patents that last less than 20 years. They're easier to obtain than invention patents. I will not really talk about that. I'm just mentioning this to you because you might hear of these terms. So, let's talk about invention patents. Okay. invention patents are designed to protect inventions. An invention patent, a patent, is a right granted by the state in response to an application by an inventor that covers a novel product or process. Okay, that is a definition of it, if you want. Okay, that's one definition. There's a lot of other definitions. I just happen to like this one. Now, when I say invention patent, the thing you have to be careful about is that it covers an invention. It does not cover a discovery. And an invention is not the same thing. So if you have somebody who discovered electricity, that's a discovery. If he had invented something that uses electricity, that's an invention. So you just have to be careful about this distinction. Okay? And you can look at this. Discovery adds to the amount of human knowledge, but invention involves the suggestion of an act to be done. It must be an act which results in a new product or a new result or a new combination for producing an old product and an old result. So this is rather interesting. An invention can be something new that results in something new. It can be something new that results in something old. It's still an invention for patentability. Okay, so patents, as you noted before, are expensive. Okay, for the price of getting a patent in some places, you could buy a car, and not a cheap car either. They are jurisdictional, which means that they only apply to a particular country. So the patents of America, more or less, the Patent Law of America covers patents in America. It does not cover patents in China. China's law does not cover patents in America, etc. Okay? They are very expensive because invention patents are examined. What does that mean? It means that you put your application in and somebody looks at it very, very carefully. And I'll talk about what they're looking for in a minute. There are also fees involved in getting the invention, in maintaining the patent. There are fees to get the patent, and there are fees to actually have it drafted. But a patent gives you a monopoly right, okay? And there are certain things that you can do with it. You've got patent rights for products, and if you get a patent on a product, you can prevent somebody else from making, using, offering a patent, a product that is patented. You can also get a patent on a process for making something. And when you have a patent on a process, you can not only prevent somebody else from using the process, you can also prevent people from importing or selling products made with that process. Again, patents last about 20 years. Any questions so far? Now, the one thing that you get with a patent, however, is that you get the protection. But the protection does come at another price, in that you actually have to tell the world how your invention works. That is the deal. You get this monopoly protection, but you must tell the world how your little thing, your little invention, works. So you can't keep it secret. And there are other ways that the patent can be revoked. In other words, somebody can make a complaint into the right authorities, and if they get through the entire process of revocation, as it's called legally, your patent can be revoked. In other words, you don't have a patent anymore. The other thing that's dangerous about patents is that the government, for some reason, can say, well, you know, I like your invention, and I might want you to license it, even if you don't. So they can force you to license, under the right conditions, your invention, even though you have a patent to it. They have to pay you back of course. They have to pay you something, but nevertheless, they can do this under certain conditions. Now, an example is if you have an emergency, medical emergency, and they want you to license your magic drug to prevent this emergency, they'll force you to do that. And they can do that legally. So it's something to be aware of when you get a patent. Patents, though, protect inventions that are behind many products. This is a set of patents that protect, these are old patents, that are behind this. Pringles. Pringles, in fact, or more accurately, processed potato is actually covered. There are actually several patents that covered this process of manufacturing Pringles or something similar. There are also things that are covered by patents that are kind of funny. This is a patent for cutting turkey. This is a patent for a golf swing. Okay, yeah. This is a remote-controlled turkey decoy. And this is my favorite. It's a patent to play with your cat. Okay.
Cat will pay with that.
Yes. Yes. So any of you? Now, actually, this is a really interesting. This is a sort of an example of getting a patent without enforcing it. If I was to actually take this laser pointer and play with my cat and do this and make my cat do all these funny things, and I would actually technically be violating this patent if I did this in America. Of course, the guy who has this patent is probably not going to come after me and ask me for some money. So again, if you get a patent, you have to actually be willing to enforce it in some way. Otherwise, you just got something that an asset that you're not really using. So that's just something to keep in mind. Now, I said that patents are examined. This is where things get a little difficult, so I'll go a bit slowly. To get a patent, you actually have 4 things that you have to overcome. You have to have something that is novel. Now, patent law definitions are not like dictionary definitions. See, novel in a patent sense means that it's not in the state of the art. Okay, so let me give you an example. Let's say, let's say you use Panadol. You have a headache, right? Take Panadol. Okay, Panadol's old. It's been around, or rather, acetaminophen, which is the chemical term, is old. And if you found a way to use Panadol or acetaminophen to make, let's say, ice cream, okay? Well, let's just be completely ridiculous. You make ice cream with, take milk, throw it in your Panadol, do something with it, and voila, okay? That is novel because it's not in the state of the art. Nobody uses Panadol to make ice cream. So that's an example of what is novelty, okay? There has to be something that is called inventiveness. It could be called inventive step. The Americans call it non-obvious. But it has to be something that is really not obvious to do, something that is considered inventive. And going back to the Panadol example, if you use Panadol to make ice cream, that's pretty inventive because nobody would think of using Panadol to make ice cream. Okay? It has to have industrial application. That's not too hard. But the more controversial part is that a patent has to be what is called patentable subject matter. And most laws do not tell you what is patentable subject matter, rather they tell you what is not patentable subject matter. So there are things like mathematical methods are not patentable, discoveries are not patentable, presentations of information are not patentable. In Hong Kong, medical treatments are not patentable. Animal treatments are not patentable. This is not true in the United States. You have something called ordre public, which is a patent in some places can be revoked, or patent application can be denied because it violates public order, whatever that is. Okay? And again, people go through this expensive and time-consuming process because you get a monopoly right with a patent. Okay? Now, let's talk about where you get patent rights. Patents obviously are used for inventions. So they are, you would, for example, a new kind of printer, a new kind of game interface might be patentable. Methods of producing, say computer chips, can be patented. It is also possible, and very controversially so, to get a patent on software. In fact, this is an example of a software patent on an electronic learning system. It's still this particular patent is actually still in effect, but it's not enforced. Just to show you that it is possible to get a patent on software. Okay. Any questions on patents before I get into copyright? Okay. Now this is probably, copyright is probably be of more use to you because you guys are game designers and you probably are involved in also designing some software as well. So copyright really arises in artistic works. Okay, artistic works being film, being music, being books, etc. Copyright really comes into play when you make a copy. Okay? It is a right to stop unauthorized copying. So if somebody copies your database, you have a problem. You can use copyright against it. If somebody copies your software, you can write against it. But copies your broadcasts, you've got a right against it. But let's say we have two people in the room. Let's say you draw a picture of me for some reason, and you draw a picture of me for some reason. And the pictures end up looking the same. Is there a problem? No. Okay, and I'll get into that. However, the copyright problem arises if he copies his picture. So if they both draw a picture of me, there's no problem. But if one draws a picture, copies somebody else's picture, then there's a copyright problem. See? So remember, with copyright, you just remember the term copy. Okay, and then you know when copyright comes into effect. Copyright comes automatically. You get copyright, the minute you put something together. And it's designed to encourage creativity. And it has a lot of international conventions. I won't get into that. But it protects, it is not a monopoly. Patent does give you some kinds of monopoly rights. Copyright does not. And copyright protects the expression of an idea, but not the idea itself. Give you an example. You have a girl, Roberta, and she writes a letter to her uncle in Los Angeles and says, "Dear Uncle Harry, the air pollution in Hong Kong is so bad that I want to, when I get back to Los Angeles, I want to stand in the middle of the Santa Monica Freeway and breathe in the fresh air." And this is the Santa Monica Freeway. Now, the idea is the air quality in Hong Kong is not good. The way she says it, however, is quite different. So the idea that the air quality in Hong Kong is bad is not really protectable by copyright. But this, the way of expressing it, would get copyright protection. And that's what copyright protects. It's the way you say things, the way you express things. Okay, again, it gives people the rights to encourage them to create. It gives people incentive, it tries to protect their money stream so that people who, create photographs, create artworks can get money and live. And how does it relate to IT? Now, this is I'm going to slow down a bit. everybody talks about protection of computer software. And yes, it does protect software. But let's remember that software does not include just application programs. That does not just include game programs. It also includes apps. It also includes drivers and printers or various other devices. It also includes graphic programs. Okay. Copyright also will cover what are called preparatory design materials. So when you create an application, you might sketch out the application workflow, you might sketch out the user interface. Those sketches could be protected. It can protect the database behind some application. It can even protect databases themselves. It can protect computer-generated works and works that you store in a digital format. Okay? Any questions on copyright? Yes.
Let's say if there's a drawing which has copyright, and there are some people on the internet, like they would do something like they will take famous pictures and change the faces of the character inside that pictures and use it to express something else he wants. So would it violate the copyright of the painter?
Oh boy, that's a very good question. Well, let's see. Okay. Copyright lasts a long time. Okay, let me just start. So it lasts, let's say in the case of a painter in Hong Kong, it lasts 50 years after the person dies. So let's say the person has died and the painting is 70 years old. Okay, the painting is now what is called in the public domain. So you do have, the painter actually has no, well, his family has no rights to it. Now if it's a newer work and you've changed it, that's a controversial area, believe it or not. There's actually a lot of debate whether, in the case of sampling music and changing that, whether that's actually part of it. You've got a lot of people on both sides, quite frankly, so it kind of depends on a case-by-case basis.
Mm-hmm.
Some people would say that you have a right to make, funny pictures that are, satirizing or making a parody or making fun. And some of them, other people will say that you do not have the right. Now, this is for stuff that's not in the public domain. The answer is maybe, maybe not.
Mm-hmm.
Okay, that's a very difficult question. If it's like an old painting like the Mona Lisa, and you make a parody of it, well, chances are it's not going to be a problem. But if it's a new painting, it might be. Yes.
I got it.
Yeah.
Yeah.
Can you give us a broader idea? I know you already talked on patent and copyright in cases where you export to other countries, because you mentioned jurisdiction. Does that work also with copyright and patent?
Oh my gosh.
Okay.
No. Okay. Okay. Copyright has copyright has benefits of international conventions. So you have certain rights under copyright, no matter where they are. Okay. So you actually can you do have a certain, not to get too much in detail, but yes, you could actually have certain rights. Another person who has copyright, another author in, say, America could have copyright protection in another country, depending on which conventions they've signed on to. Patent. To give you the easy answer, no. So in other words, you have a patent in America, and you bring somebody brings it into Japan. Well, that's too bad. Okay, but if you had a patent in Japan and they brought it in, then you have something. Even though if it was made in America, it was designed in America, but you have a Japanese patent on it, you can do something against that other person. Okay. Yes.
Talking about computer software or codes, I want to know how deep can the copyright protect my stuff? Like, can it protect the design pattern, or only protect the code itself? I mean,
Okay, okay.
framework.
Okay. Yeah. All right. Let's go through the application. Let's look at a game application. You actually have several items within a game application. You have the algorithms that power. Well, actually, you have the algorithms that would dictate how the let's say the game operates. Okay. You actually have certain workflows that you have. Now, if you've actually sketched out the workflows, as that would be a preparatory design material, if you will. That would be protected. Now, in the case of the coding, you have copyright protection on the graphics on the software. You might have other protections on the icons, which actually is a design right. But you might actually, but if the icons are really complicated and really interesting or really artistic, you can get copyright on the icons. You can actually get copyright on the coding itself. Okay, so the code, the code actually would get copyright protection. Okay, what else would you have in the game? If you have a trademark, which I'm going to get into, then you also have the trademark right in the game. If you happen to have you happen to own the trademark, so and you put a trademark logo that you happen to own in the game, then you would also have the trademark rights to that. And the trademark itself, if as a graphic, if it's sufficiently interesting, might actually get a degree of copyright protection.
Do I need to like apply to it? Like, I mean, does the copyright of my codes come natively, or
copyright comes automatically? With the but just remember, except within certain places, copyright comes automatically. The United States is one of the exceptions. United States, you get copyright protection automatically. But if you want full protection, you have to register it. If you want full protection in Hong Kong, it comes automatically. You do not have to register. Okay. This is why people get confused on copyright law, because it's very different from jurisdiction to jurisdiction. Sorry, yeah.
And also, what's the difference between the copyright of the software and the some open source license? Like the license is it different from copyright?
You really want me to get into open source licensing? You really want me to do that?
Maybe we'll discuss later, because I...
Okay. No, actually, that's a really controversial area. Generally speaking, in open source licensing, since you asked the question, generally speaking, in open source licensing, they're all pretty much patent after the GNU license. Right? Okay, so let me just talk about the GNU license and the main concepts behind that. Under the GNU license, everything you take from, let's say, the original open source product, essentially you can't take on the follow-on rights to the software. So you can't, if you have a patent on the software that you create with the original open source code, you will not be able to enforce the patent. You can get the patent, you just can't enforce it. Do you have the copyright right to it? Yes, you do have the copyright right to it. What can you do with it, however? Well, that actually depends on what you're trying to do with it based on the license. Now, right?
I got your name.
Yeah, because
other people they didn't copy from the GNU, they got the right also, but
to
they're not
use
copying
it.
yours work.
Yeah.
So it's no point to get the patent for it.
Well, you could get a patent, but there's no point. You can't enforce it. I mean, if you want to get a patent just because you have $400,000 that you don't know what to do with, you go ahead, get one. But you rather have a patent than a BMW. Go for it. But seriously, it depends on the license. The GNU, the open source licensing, generally, when you take a follow-on product, you cannot protect the follow-on product. So if you use an open source product to create another product, you must make the product you create available to somebody else to use so that he or she can create something else with it. Okay, that's just to put it very, very non-legally. That's essentially the essence of it. The exact rights under the open source license do depend on the different licenses, but generally speaking, if you get a open source license, you can make money from anything but the software itself. So you really cannot sell the follow-on software per se, but you can make money off services. Like Apache, for example, Red Hat Apache, Red Hat, they make money from providing technical support for their product. Okay, they don't make money on the product. If you look at Apple, Safari is an open source product. OS X is based on Darwin, which is in turn based on that Berkeley software, Unix, which is really, in some ways, to some people, it's sort of one of the first open source products. But again, Apple does not make money selling Safari. Okay, they make money on the things that come with Safari, like iPads and iMacs, etc. Okay, so you don't make software with an open source system. You don't make software. You don't make money on the software itself. You don't restrict the software. You see, open source, and this is where a lot of lawyers get confused, by the way. Open source is designed to protect the freedom of software. And in the case of freedom, or free, in open source, it means free to use, not free to buy. I mean, okay? And this is serious. I actually had a conversation with a company I used, a friend of mine who works for a package company, a small package company. They call Federal Express. And I actually had worked on their software supply chain system. It's the one that it's essentially the older version that later became the IT hub for the supply chain that they use for Foxconn to deliver Apples, also used by Sony, etc. But the one problem that they had a problem with their U.S. lawyer, and he was saying that you can't make money off of open source because everything's free. But the fact is, you see, he got the interpretation of open source wrong. Open sources does not mean that software is free, that you cannot make money from software. It's just that the idea is to keep the software free to use, free from restrictions, that kind of free, not low cost. Okay? Did that answer your question? Oh, you got more questions.
Yeah, because if I integrate a piece of open source project into my game, let's say, and does it mean I can sell this game on Apple's store? I mean, I've heard of there are several different kind of open source license.
Yeah.
One is called GPL. That's completely what you.
It's GNU. GNU GPL. Yeah.
Yeah. What you mentioned, and then I also heard some other licenses, like Apache, those kind of licenses. Maybe you can commercialize your product using the code under that license. Maybe. So I'm not sure because I'm doing kind of stuff right now, so I'm just concerned.
Well, generally speaking, you have to actually look at the actual license very carefully. But so there's something.
It's so long.
Yeah, I know. Well, I actually wrote a paper on the Open Office XML standard, OXML, and let me tell you, the license is really long, and the technical specs. The summary was 50 pages. Okay, the technical specs were 400 pages. Okay, it's no wonder nobody understands it because you have to read the license with the technical specs, and by the time you read the license, you're too tired to read the technical specs. Generally speaking, this it's probably better to if you're going to use open source, you should have the business model that supports it's not a traditional licensing model, shall we say. It's a traditional licensing model, meaning like, for example, Microsoft, they sell Word for whatever amount of money. You used to go into a store, you buy Word or Office, and log onto your system. You should actually have a business model that does not rely on that. Rather, if again, Red Hat, they don't rely on software revenues. They rely on other kinds of revenue. So if you wanted to make the application free, for example, but you actually relied on a different business model where, let's say, people pay you to put in their trademarks, for example, then that's actually you have no problems. Okay. Would they let you sell the software? Probably not. If you look at a lot of licenses, but you can make money off of it. You just have to be a little bit more creative. Okay. Any other questions? All right. Let's talk about trademarks. Huh? What?
We can ask later also.
Yeah, if I don't run away first.
No,
No, yes, not.
Because let's say they're developing a mobile app, and can you give us an idea of copyright in Hong Kong for mobile app? The cost or?
What do you mean?
You said in Hong Kong there's a full copyright.
Okay, basically, okay, yeah. Let's say let's say you create a mobile application. We call it Happy Birds, not Angry Birds. Okay, you have these funny little graphics. Those graphics might be copyrightable. Okay, the background screens. Okay, like let's say you have let's just say Angry Birds for a minute. You have the Angry Birds. You have the stupid bird, and then but you also have the background. With those have copyright because it's graphics. You have the copyright in the software. You have if they're databases, you do have some limited copyright in the databases. Okay, and then of course any kinds of materials you had to design the product, to create, again your sketches, that would have copyright protection. Okay.
Actually,
Yes.
real quick, related to that a little bit, for the students that are working on projects right now, can you talk a little bit about employment contracts? Because a lot of them are using freelancers and everything that are creating artwork. And there's an issue there where if your game becomes successful, they may, just from an employment contract point of view, how can they basically protect themselves?
Okay.
On the IP issue.
Okay. The easy answer is make sure they're all employed.
That'd be great.
Sorry. The easy answer is the easy answer to that is you just make them all employees, and then put in their employment contract. You get all the IP rights. Seriously. If you actually no, because you see under the copyright ordinance you do have that protection, that provision that unless you have something in the employment contract of an employee that says that something to the contrary, the employer owns the intellectual property rights. So therefore, if you are hiring somebody, then it's very important to just put in the contract who owns what. Okay? I mean, that's just the easy and simple answer. Okay? So you got a trademark? Okay. Now, I know you guys probably think that trademarks are these logos or some kind of signs to differentiate product, and they are. Okay? I mean, I'm just using the Wikipedia definition, but a trademark is something that is distinctive. So to get a trademark, the mark has to be distinctive in some way. Distinctive in design, distinctive in the coloration, etc. And the reason people get trademarks, and the reason is because they try to remember to put batteries that work in these things. Okay, forget it, we're going to do it the old-fashioned way. And so you actually have trademarks that are designed by people, and you can see that there is something distinctive about them. But the reason you have something distinctive is because you want to associate this particular mark with your brand. So in the IT sense, trademarks are valuable just if you want to establish and protect the brand image. Now, where trademark law becomes even more relevant is the fact that trademarks nowadays don't just necessarily cover graphic marks. Okay? again, they're jurisdictional, but they're registered. But a trademark can be a word. It can be an image. It can also be a smell, believe it or not. Bridgestone, believe it or not, actually has a trademark in the UK, if I'm not mistaken, on tires that smell like strawberries. I kid you not. It can be it can be a color. It can be a smell. It can be a sound. So if you listen to the Intel sound or the Apple, when you power up an Apple, that's a trademarked sound. So you have to be careful about trademarks, and that nowadays they don't cover just these graphic marks, the IBM logo or the Lexus logo or the BMW logo or the Mercedes three-pointed star or whatever. They also can cover things like sounds, like smells, depending on which country you're talking about. In Taiwan, you could even get a trademark on a hologram. Okay, so this is where things get a bit interesting with trademarks. And unlike patent law, it is not a monopoly. All the trademark really does is protect against confusion. But unlike patent law, and unlike copyright, a trademark can last indefinitely as long as you pay the money. Okay, so you register a trademark and you pay the fees, and you can have the trademark for a long, 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 long time. Okay? Any questions on trademarks?
Is it free?
What?
Does it need to register or?
Do you have to pay for it? Okay. When I was getting my patent, a U.S. patent license, I actually was talking to somebody who worked at the U.S. Patent Office, and he said that, you see, the United States Patent and Trademark Office makes money, unlike the rest of the United States government. It actually makes money. It's very profitable. It makes a lot of money because it has a lot of fees. You have to pay to apply for a patent. You have to pay to register your trademark. If you want to do something with your patent application, you have to pay for it. If you want to do something in your trademark application, you have to pay for it. You want to change something in your trademark, you have to pay for it. You see, if you go to Hong Kong and you go to the intellectual property department and you do some registered trademark, the first thing they ask you for is your form, and the next thing they ask you for is your money. Okay? And they they have a set of fees. And the fees change all the time. So yes, you have to pay money for it. So, some things you don't have to pay money for, but many things you have to pay money for. So when you have to register something like a trademark or a patent, or in the case of the United States, copyright, you have to pay a fee. Okay? As I said before, if you want to get an intellectual property right, you have to be willing to pay to get it in many cases, and then you also have to be willing to enforce it. But to get a patent, you have to pay for it. To get a trademark, to register a trademark, you have to pay for it. Okay, and this does not include, by the way, the cost of actually creating the mark. If you get a designer to design your logo, you have to pay for that. If you get, in the case of a smell, somebody to make a special smell for you that you want to trademark, you have to pay for that. Okay, so yes, that does cost. Okay. Any other questions? Don't worry, I usually in my law classes I drink 3 of these. And I fall asleep at 1 o'clock. Now, I guess you guys all know what domain names are. I'm only going to mention this really kind of in passing, because a domain name could actually attract trademark-like disputes. You see, what happens is you have people who get domain names, let's say sting.com or whatever, let's say novacourses.com, whatever. And you have different people who get the same names, and sometimes they don't like it, and they fight amongst themselves. And so they create disputes that really are a lot like trademark disputes. And these disputes are decided on the fact as to who should be the rightful owner of this domain name. And in the case of trademarks, trademark disputes kind of work in the same way, because you get a trademark, you register it, and if somebody wants to challenge this registration, they have to prove that they have a right to the mark just as much as you do. Okay? And that's the same kind of principle behind domain names. And they're registered. Now, I'm not going to cover it, but what I'm going to cover are some other rights. Geographic indications, I'm just going to mention it very quickly. These are something you're probably not interested in, but it's just for products that come from a particular area. That, for example, if you have, in the United States, you have Florida oranges that are supposed to be better than oranges from other places. So that's a geographic indication. Idaho potatoes that McDonald's use are supposed to be better than potatoes that come from other parts of the world. So that's a geographic indication. That's all it is. That's all you have to know about. But this one you do have to know about. It's called a publicity right. Now this is something you don't necessarily hear in IP talks, so I'm going to talk about this. A publicity right can be called a personality right. It can be called a right of publicity. It can be called a portrait right. Essentially, it is the right of an individual to control his or her image or something associated with that particular publicity. Now you have two cases here that involve two singers. One is Tom Waits, this fellow, and that's Bette Midler. And what happened in their cases was that in the case of Tom Waits, Frito-Lay, people who make Lay's potato chips, had an advertisement with somebody singing, and that person sounded like Tom Waits. And Tom Waits didn't like it. Similarly, in the case of Bette Midler, Ford had an ad with somebody that sounded like Bette Midler, and she didn't like it. It took Ford to court. Now, you might think that this only covers celebrities who have ads made that they don't like. Well, actually, it also can cover people who have companies which celebrities do not like. Now, for those of you who are not aware, if you go, there was a talk show host many years ago in America called Johnny Carson, and every time he would start a show, there would be his right-hand man, Ed McMahon, and he would say, "Here's Johnny." And everybody in America associated "Here's Johnny" with Johnny Carson. So when this company created named itself, this toilet bowl maker, named itself "Here's Johnny," Johnny Carson didn't like it, and took them to court based on publicity rights. Okay, so now I don't think any of you are going to hire Lady Gaga to do advertising for you, not yet, or create Beyonce Knowles or type products, but publicity rights are very relevant in games. Okay, and let me start with this one. This is a 90s disco singer named Lady Miss Kia, and Sega had created a game, actually with her her input, by the way, but she and Sega were negotiating, and Sega and her broke off negotiations. Nevertheless, she sued Sega and claimed that this character, Ulala, was based on her, and that she should get some money on the the basis that she was or her character was in this game. She lost the case in the end. Nevertheless, it does show you that people, celebrities who are used in games or who think they're being used in games, will sue you, game producers, because of publicity rights. Now, a more recent example involves Courtney Love and her late husband, Kurt Cobain, and she did not like the way Activision was depicting Kurt Cobain in Guitar Hero 5. She just made a complaint, though, She never took them to court. However, this group did take them to court. No doubt, took them to court. And their complaint really centered around the fact that they had in the Guitar Hero game avatars that look like them, and for somehow this backdoor was made available to some people, and using this backdoor, people could reprogram the avatars. So, for example, you would have Tony Kamal, this guy, the blonde guy, singing Gwen Stefani's parts, and they were, and not surprisingly, Gwen Stefani was very upset with it, as was as was Kanal. So they took Guitar Activision to court on this. I'm not sure what happened. It's been appealed, so I don't know what happened with the appeal. But just show you that in the case of celebrities, it is possible that if you use a celebrity or somebody who looks like something that looks like a celebrity in a game, you might actually get into legal problems with it. Okay, any questions so far? One last thing, not every country has publicity rights. China has publicity rights, Hong Kong does not. California has publicity rights, but other states in America do not. Okay, so New York has it too. Now, some other rights. You can get rights in plants or seeds, so if you guys want to give up designing applications and start growing plants, go right, no, this is of use. Otherwise, don't bother. If you're designing semiconductor masks, or there is special protection in Hong Kong for these. Just for your information, most people, companies like Intel and AMD who design and produce chips do not actually rely on, rely a lot on patents, but not on, but the patents don't actually cover the integrated chip, the IC itself. The patents cover the processes, all the technologies behind them. And this is really because by the time they get a patent and you go through the whole process, the technologies have moved on one or two more generations. So, but for those of you who happen to be designing ICs, that's for you. If not, don't worry about it. These things are called, you have something called sui generis rights. Sui generis is a Latin term for in the thing itself. And the most relevant to people like yourselves is a database right now. You're probably saying, well, copyright covers databases. Yes, it does, but it's not great protection, okay? Copyright gives good protection for books, gives good protection for music. The protection for databases is not quite as strong. So what happened is some countries, or some jurisdictions like the European Union, created a special database right. So it protects the database itself. And the reason for this is because if any of you have ever created a database, you know what a pain and you know how much trouble it is to create the database and to update the database. And sometimes if you have to cooperate with other people, you know what a pain it is to actually do the updating process. So that's why you have database rights. Okay, any questions? Now, I talked about design patents, and I talked about design rights, and to answer your question about the application, and I talked about icons getting design rights. This is where design rights come in. Design rights, which are called registered designs in Hong Kong or design patents in China or America, are designed to protect things like icons, features of a particular product, like industrial design. And the reason you have them is because these designs might not be artistic enough to get copyright protection, but you still want to protect them, so you have design rights. And icons are actually a good example of things that get design rights. You have to apply for a design right, okay? There's certain criteria. And design rights, for those of you who have been following the Apple and Samsung problem. Design rights were really central to the tablet. So if you looked at the problems they were having with the tablet, you know, and you see all these people talking about Apple getting upset with Samsung and they violated Apple's design patents. This is actually what they were talking about, is these design rights. It wasn't a patent on an invention in the tablet. It was actually just a design right on the tablet. So this is where design rights come in. So if you have a device that has an interesting design, okay, and you have a registered design right on it, then you can get protection for it. You have protection for it. Okay, Icon, again, as I mentioned, could get design protection. Any questions? All right. Most important. Second coffee. This was my secret to getting through law school. Coffee. Lots of it. According to the doctors, I'm not going to get Alzheimer's disease given how much coffee I drink. Now, we're starting to get to the end of the presentation, but let me talk about something that's extremely important. These are trade secrets. Now, sometimes people call these intellectual property rights. Some people don't call them intellectual property because they're not registered the way you register trademarks or patents or copyrights in some cases. Nevertheless, I think they're very important, so I will cover it. A trade secret is something that has commercially important information. It does not, you have to actually protect a trade secret. Now, what could be a trade secret? Well, the most famous trade secret in the world is probably the formula for Coca-Cola, Formula X, which is secret. In the case of IT, a trade secret could be a list of customers. It could be the applications. It could be the algorithms behind certain applications. For example, search algorithms are always secret. Okay, well, people, or at least the Google people, like to keep it secret. Database contents could be secret. Financial information could be secret. So these are all things that could be protected under trade secrets. Now, to get a trade secret, you have to keep it secret. Otherwise, it's not a secret. I realize you laugh at it, but it's actually true. You have to take steps to protect the secret. That's how you protect it. Now, the problem, of course, is that if somebody comes up with the trade secret by accident, you don't have a trade secret anymore. So let's say Paul, okay, he accidentally comes up with the formula for Coca-Cola just by accident. Guess what? It's really no longer a secret. Coca-Cola can pay him a lot of money to keep his mouth shut, but there's really not much they can do to protect the fact that the trade secret has been compromised. All right, and of course, if you do have a business that depends on secrets, like Google has with its search engine algorithms, then you would use trade secret protection because you cannot use patent protection because one, you can't patent an algorithm, and two, even if you could patent the algorithm, you have to make it public if you get a patent. And the last thing they want is to make their algorithms public. So that's why trade secrets are important. Now, get into this is kind of more competition law than IP, but I'm going to talk about it. Some IP books talk about passing off, or sometimes it's under unfair competition. Now, passing off is really means that you're trying to do something or with something and pretend that that thing is somebody else's. Okay, so for example, let's say I take this coffee, I make my own coffee, and I try to pass it off as Starbucks coffee, even though it's, Starbucks had nothing to do with it. That's passing off. And the idea behind passing off law is to protect people from essentially getting ripped off by fraudsters, okay, who are trying to pretend that the thing that they're doing, the product that they're making or selling is yours when it is theirs when it's really yours. Okay. Now, why is this so important? It's because passing off and trademark law are very tightly related. Okay, and people want to know why you get a trademark. Well, to some extent, you get a trademark because you don't want to go to court on passing off. Now, what does that mean? Well, let's say I'm passing something off as this coffee off that I've made, that I've grown in my plantation in Fanling, as Starbucks coffee, when it really isn't. Okay? What does Starbucks have to do? They have to come after me. Let's say I use this, something like that, as this package for my coffee. Well, Starbucks has to show under passing off that they have the right to this symbol, that I am using this symbol maliciously or basically to rip them off, that they are losing something. Okay. Now you think about that. If you actually had to do this in a court of law, that's actually quite a bit of work. Because you have to show that you have some right to this mark. You have to show that, this mark has some value to you. You have to show that I am using this mark to profit from it, and that Starbucks has to show that because I'm using that mark, they're losing something from it. That's quite a lot to do in a court. So that's why you have trademarks, because once you register a trademark, if they've registered the trademark, all Starbucks has to do is go up and say to the Customs and Excise Department, Ron, over here, is using our mark. Our mark is registered. We own the mark. So put him in jail. That's it. Okay? Much easier. So that's why a lot of people get trademarks, because they want to avoid a lot of litigation in passing off. Now, some IP books will talk about privacy rights. The reason why you have privacy rights here is because publicity rights, remember that? With Gwen Stefani and No Doubt, that actually derived from privacy law. So that's why you start to see privacy coming into a lot of intellectual property. So the reason why intellectual property is complicated is because there's a lot to know. There are a lot of things that are now coming into intellectual property. Publicity rights, for example, derive from privacy rights. You had domain names which went around 50 years ago, okay? And there are things that are still developing that are not entirely clear to a lot of people. So where does everything fall in, if you will? Well, if you look at computer programs, integrated circuits, databases, products like iPhones, etc., and then you have people who provide services, software as a service, ISPs, cloud computing, virtual online games, etc. You can see where some of the rights come in and where they overlap. You have copyright for programs. You might have trademark rights. You might have design rights in computer programs. There are secrets, for example. They are in databases. You have sui generis protection. In ICs, you have patent protection, as well as, in some cases, protection for the IC itself. You have design rights for products, trademarks of products, domain names for internet-related issues. And that is it. Any questions? Did I scare you?
How is it, just a question, like Disney, they keep going to the courts or something to get their copyright extended. How can they do that?
They have money.
So they just keep.
No. Okay. Copyright traditionally and under the World Trade Organization's Agreement on Intellectual Property, which is called Trade-Related Issues of Intellectual Property, or TRIPS, is supposed to be essentially 50 years. Okay, so it's like 50 years from the death of an author, the death of a composer, or in the case of film, let's say the last, principle, for example, the films, like the cinematographer, the producer, director, etc., plus 50 years. Okay. In Europe, it's actually been 70 years for some time. So in the case of what you're talking about, people like Disney lobbied for what has been referred to as the Sonny Bono Amendment, but to extend the copyright to 70 years. And the argument was because, of economic rights, but also because in the case of the United States before that was actually 50 years when Europe was 70. So there was an inconsistency. So that's why they got it. There's actually been talk about extending it to 90 years. Yes?
Can you talk a little bit, I guess now, especially in technology, with like, there are a lot of issues happening with like Samsung, and you mentioned and Apple, and actually because the market is being so competitive, I guess lately, because of the legal issues, they're able to take products off of the market, right? So it seems like there's a big war going on. It's not really on the economics or on the marketing side anymore. I see it kind of as, I don't know, just as kind of a dirty fighting kind of a thing. And the end result for the consumer is actually worse, right? Because there's less competition because of the IP related issues. And then on the one hand you have that, and then you have all these big companies now buying other companies mainly for their IP.
You mean like Nortel?
Yeah, so they're just buying them just to protect themselves. And then you have companies like, the new companies like Intellectual Venture Partners.
Intellectual Ventures.
IVP, who basically are almost like a mafia. They basically come in and they say, hey, we've got this huge database of patents, and if you don't sign in with us, you might get sued by someone later on. And it's almost like borderline extortion, if you will. And so in this technology area, and because technology is advancing so quickly with, Moore's law, computer performance doubling, and markets becoming bigger and bigger, it seems like a lot of this IP-related issue, and it seems like very simple things, like, like on the Apple versus HTC side, just the whole swipe to unlock your phone, that they're arguing over, simple, dinky interface things, like this. Can you talk about how you see the development of technology in the future and how this IP issue is becoming increasingly important and how that will play out?
Do you have a week?
Well, obviously it creates more business for people like you.
I'm an in-house counsel. I actually have to worry about things like this. I'm a patent agent, and theoretically, it would create more business. Also, creates a lot more headaches. What you're actually asking, to some extent, is a question on well, at the same time, you're talking about questions of ethics, business conduct, patent, business strategy, and patent and IP strategy. So let me try to answer the. Let me start with this. It shocks a lot of my students in law class that I tell them that the first thing they consider with patent law is really the business model, and also in IT and IP, you have to consider the business model, and it's because a lot of lawyers have this, or at least are taught, at least in Hong Kong, they're taught that law is law, business is business, but in fact, because of the expense of IP, you actually have to consider IP is to a large extent is a business decision. Okay, as you've seen in this presentation, you can use IP defensively to protect yourself. Let's say, in the case of trademark, against the expensive passing off case, because it's easier and cheaper to register a trademark and then get somebody who's infringing your trademark, using trademark law and trademark registration, than try to actually get it, use this law of unfair competition or passing off. Okay? In the case of intellectual ventures, Nathan Meerholt, who started it, for those of you who don't know, Nathan Meerholt was the essentially the IT head of Microsoft. Before he went to Microsoft and essentially was one of the principal architects behind Windows, he was a principal architect at a company called Digital Equipment Corporation, which was later acquired by HP for their VAX VMS system, their operating system. So he's actually an operating systems guy. He has quite a lot of expertise in operating systems and software. And the intellectual ventures model that you mentioned is really is a patent aggregator. So they get a lot of patents and other IP rights and put them together and sell them. That's their model. And as their business model, as you correctly pointed out. IT patents are kind of good until the technology changes. So if you, for example, got a whole lot of patents on Windows and everybody abandoned Windows operating system tomorrow, the patents would be worthless. Okay, so there's a lot of risk involved in getting an IP portfolio. That having said that, IT is mostly is a bit like design and other kinds of creative endeavors, is that it builds on what was done before, and that's really what is at the heart of your question, is what to do about that.
In this hyper-competing kind of environment.
Honestly, a lot of people don't have a good answer to that. I really don't know. The hyper-competitive environment actually goes back much further than the current Apple, Samsung, Apple, Motorola, Apple, HTC wars. If you look at Kodak, remember them? Kodak, before they went bankrupt, created a instant film to compete with a company called Polaroid. Okay, and those of you who have seen Polaroid, it's an instant film. You take a picture and you wait a few minutes and you can see a picture. And they had a lot of litigation on that. Now, the reason I bring that up is because Kodak actually hired an expert to design around Polaroid's patents. So he said, well, I've got a process that doesn't infringe on Polaroid's patents. And you should be safe with this new process. Actually what happened was he reviewed the Kodak process and told him, okay, don't do this, don't do this, don't do this, don't do this. Okay. And Kodak nevertheless got sued, ended up paying $900 million, which was a lot of money at the time, to Polaroid. So the problem, I think, with any kind of technology is you can get two experts who can give you two different opinions. It's a bit like getting a doctor. You've got doctors and who see the same symptoms and come up with completely different diagnoses. You can have this problem with intellectual property rights with regard to technology, and it's not necessarily clear where a technology ends, one technology's boundaries end and the other ones begin. So I really don't have a good answer for you. It's kind of a very much, it depends. There's a lot of controversy. Okay, since I wasn't planning to talk about it, since you brought it up, there's actually a lot of controversy in this. There's actually a lot of controversy with copyright law in IT for a lot of reasons. There's a lot of privacy. I mentioned also comes in the case of mega upload. You saw,
yeah, that one.
yeah. Privacy rights now have come in, not because of IP rights, but you see, mega upload. The United States government seized the data on the confiscated the data on the servers that Mega Upload was using in Virginia. Now the problem is they actually got people. Well, they got people who were pirating software, music, or film. They also got a lot of innocent people who are now quite understandably upset. So you also have a problem of that, if you enforce something, your IP rights, you could actually be violating a whole bunch of other rights. So the whole thing has gotten extraordinarily complicated. So that's kind of why I didn't want to talk about it in this kind. But sorry, going back to your original question, the intellectual property rights are, that whole area is now being explored. It's extremely difficult. But
So basically, whoever has more money, that's
kind of, yeah. I mean, it's kind of, yeah, whoever's got more money. But it doesn't mean that it doesn't mean that the person with the most money is going to win in the end. It's just a matter of the other party, how good their intellectual property right. Let's say their patent is. If it turns out that patent is better than intellectual property ventures, intellectual ventures 600 other patents on the same technology, well, you're okay. They're okay, Does that sort of answer your question? It's a very long maybe. Any other questions? Oh, wow. He's really excited back there. Hi. Joseph. Okay, any other questions?
If not, I'd like to everyone give another warm round of applause. I guess it is a hot topic, For us, in this program, we're focusing on new technology and innovation. And there are a lot of little things that can get you. So little things like if you're working with outsourced artists and you don't secure the rights, your game becomes big, they can sue you later on. So a lot of these little things, it's, this Chinese term, 先小人后君子. So first be the little guy and, make sure all the I's are dotted, the T's are crossed, etc. And then later on you can be the magnanimous general, etc. But it's becoming increasingly important, especially in this area, especially with the litigation and suits and all of this other stuff. And it's not only in this IT area, but now like biotech, and there are all of these new cans of worms that are being opened.
Biotech, since you're a toxicology guy, Paul, biotech is a gigantic can of worms. And the reason, I'm sorry to interrupt you, the reason it's is because biotech, particularly genetically modified products, attract a lot of attention from environmentalists and clean food people. And remember I talked about certain patents, certain things being unpatentable because of public morality. That's where you see a lot of that being used, is where you have transgenic animals, genetically modified products, and if it's also in the case of cloning, you also have a whole lot of moral issues with that. Sorry.
Well, there's that, but also in this area now, I guess with SOPA and all these other laws, so the governments are trying to do something, but everything they try to do is just screwing other things up and everything. And there are groups like the EFF and other organizations, nonprofit organizations, that are trying to look after the interests of people. And one of the challenges, even with things like SOPA, is that the language, like you were mentioning these long legal things, the language is so complicated. It's almost like elections in the United States. They'll say one thing which sounds like it's protecting you, but actually it's worse than that. And so you need experts to really trusted experts to really hone down.
I once actually asked David Llewellyn, who wrote the leading textbook in this area, actually asked the question, is it possible that, just to say intellectual property rights are getting too complicated for the layman? And he looked at me and said, you kidding? It's getting too complicated for the expert.
Yeah.
No, seriously. this took some time to actually come up with, and it's actually very, it looks simplistic, but it's actually very, very difficult. And intellectual property law is really an extremely difficult area, not just because it's inherently difficult, but because it is evolving so quickly in so many different directions, and there's so many controversies.
And again, people like Ron, and I'm actually thinking, maybe if you're interested, of even developing an elective in this area, you know, for our program, mainly because if you look at China now, and you know, China's a whole nother can of worms, but then as China tries to, you try to bring your products into international markets, you know, they usually don't really cover any of this stuff in China, I guess.
Actually, okay, let me be fair about Chinese law, simply because the professor who taught me was the lady who drafted, and I say lady, who drafted the domain name law in China. So she's really, China actually doesn't really have bad law in intellectual property. It's actually really good. The problem is enforcement. Yeah. Okay, so you have to just be careful about, as I said, you know, at the beginning, you got to look at enforcement, because
well, it has to be enforceable.
It has to be enforceable, but you know, the law itself is actually really good. Now, I should also point out, since you brought up China, there are subtle differences between Chinese law and copyright and American law, and so, you know, they have Chinese law. I didn't want to get into this, but let me, since you brought it up, Chinese law, for example, provides a lot more protection, or a lot more regard for the rights of an author. Okay, these are called moral rights, but American law is pretty quiet on this subject. So you actually have to be careful. There's some areas in Chinese IP law that's actually better than, let's say, American law. Okay, but
I think that's where, you know, the whole moral rights thing gets complicated. That's where if you hire me to write something and then you commercialize it, you have the commercial rights, but I still have the moral rights. So
yeah.
If you change it, I can actually sue you.
Right, unless I put it in the contract that it's, yeah, that's correct. It's very complicated. Any other questions?
Yeah. All right, so thanks again.
Thank you. Thanks for, listen, seriously, thanks for, I know this is a very difficult subject, especially for Friday night, when, you know, you'd rather be, as I said at the beginning, drinking, or, you know, watching a movie or something, so, thank you very much.